Stefan, we are live.
Thank you very much, Mr. Davis. Well, good evening, everyone, and welcome to those who are attending this public hearing. The public hearing is in relation to the Municipal Plan Amendment number 20, 2022, and Development Regulation Amendment number 38, 2022. That's commonly referred to as 73 Cherry Lane. My name is Stefan Yefchik. I have been appointed by the Town Council of Conception Bay South on March 1st, 2022 to act as Public Hearing Commissioner into this amendment pursuant to the provisions of the Urban and Rural Planning Act. I'm a professional planner since 1976, and since that time I have been the town planner with the St. John's Metropolitan Area Board, Director of Planning and Development for the City of Mount Pearl, and more recently until June of 2021, the town planner for the town of Logie Bay, Middle Cove, Outer Cove. My role here tonight is to listen to the town, the applicant, and the respondents to the notice, and prepare a written report with recommendations to the town council on the proposed plan amendment and rezoning. This is not a decision-making meeting. I wish to emphasize that I, as commissioner, make recommendations to council. After reviewing the report and recommendations, the council then makes the decision to either accept, modify, or reject the recommendations. Just for your information, in my written report, all written representations received will accompany the report for council's background and consideration. So all information that I have received will form part of that report. So regardless of what's in my portion of the report, they will still see the information that I have received through your written submissions. Before we proceed further with the public hearing, I want all participants to be aware that the public hearing is a virtual hearing through Zoom and will be broadcast live to YouTube, where the recording of the hearing will be on YouTube permanently. I will respect personal information and will refer to the submissions by the company name or the address rather than by individual names. All participants will be muted during the public hearing, but will be unmuted during the individual presentations of their submissions. If you have a question during the presentations, please save them until your presentation, or you can ask them during the oral submission portion of the meeting. So the format of tonight's public hearing will be as follows. Thank you, Mr. Davis. So we'll start with we'll color order the introduction, purpose, and format we've just gone over. We will have a presentation from Mr. Davis, Director of Planning and Development for the town of Conception Bay South. I will then call upon the applicant, LPM Consultants Limited, to make a presentation or give any comments they wish to give at that point. Next, we do have a prospective owner involved, and if they are present and if they wish to make comments, I will give them an opportunity to do so. And then we will go through the written submissions, and then we will go through the order in which I have received them. Then we'll go to any oral submissions if there's any during the hearing. And then afterwards, we'll allow the applicant for the rezoning to do some concluding comments. And then I will conclude my remarks on the next steps, and then we will adjourn. So having said that, I am now going to pass the public hearing for a presentation by Mr. Corey Davis, who will give a background to the plan amendment and the rezoning. Mr. Davis.
Thank you, Mr. Yefchik. As you noted, I'm going to share a slideshow to help me walk through the proposal that the town is currently dealing with. I believe that you can all see that there now. So what we're dealing with here tonight is a proposed rezoning of the property at 73 Cherry Lane. Sorry, there we go. The purpose of this presentation is just to provide a summary and background for this proposed rezoning at tonight's public hearing. So the property, obviously it is 73 Cherry Lane. It can be described as a large parcel of undeveloped land on the west side of Cherry Lane, generally speaking, between Manuel's River and Long Pond. It is south of and includes a narrow access to Windy Cove Lane as well. You'll see that a little more clearly in the next slide. The property is approximately 1.4 hectares or about 3.3 acres in total, and it has a 15-meter or 50-foot wide access to Cherry Lane. Municipal water and sewer services are available at Cherry Lane as well. So there's been a history with this property. There have been a number of earlier development proposals that have been considered by the town and for a number of different reasons have not yet proceeded. So in 2006, there was a proposal for a 60-bed assisted living facility at the property. In 2010, we had a proposal for a 5-lot residential subdivision, which would have included construction of a new public road into the property. 2017, we had an application for a single dwelling, and again in 2017, another application for a single dwelling. The zoning on the property is residential low density, which is consistent with the entire neighborhood, of course. A single dwelling is listed as a permitted use within the residential low density. However, the minimum frontage stipulated for the residential low density zone is 21 meters. And as I said in the previous slide, this property has only 15 meters of frontage onto Cherry Lane. Just picking up as well on what I mentioned in the previous slide, we said that there was a small access to Windy Cove Lane. You can see it here, sort of a tail of the property that goes over to Windy Cove Lane. That access is not wide enough to create either a driveway access nor a public road. So the request that's before the town right now is in pursuit of approval for a single dwelling. And the history on this particular file is that in May of 2021, we had an application submitted for that single dwelling. It was considered by council in June, and ultimately it was refused by council. The reason that council stated in the refusal was that the property does not meet the minimum 21-meter frontage requirement for a single dwelling within the residential low density zone. So in July of this past year, the prospective owner asked if council would be willing to consider rezoning the property to the residential medium density zone, which would allow construction of the house with its 15 meters of frontage. In September of 2021, after having received a formal application in that regard, council initiated consultation on the proposed rezoning. What you see in the graphic on the right-hand side of the screen is the concept plan that was submitted in support of the May 2021 application. And I apologize that it's probably quite small on your screens, but what you see is a house being proposed to be located approximately 1/3 the way back through the property. So could be upwards of 200 feet from Cherry Lane itself. And the notes on the drawing indicate that they would have a private driveway access and that they would maintain as many of the existing trees in front of the dwelling as possible. And it also notes, based on grades, that they intend to have a walkout basement from the rear. So the amendment, it went backwards, sorry. In September of 2021, after council agreed to initiate public and stakeholder consultation, notices were posted in the shoreline, on the town's website, advertised through our social media channels, and also mailed out to all known property owners, generally within 100 meters of this particular property. At that time, council received 8 submissions from 8 individuals, and a number of concerns were raised in those submissions related to things such as inconsistent development, the nature of traffic that would be generated, the potential loss for trees, the potential for increased density, what the future development plans might include, and one particular very specific concern about access to an adjacent property. In January of this year, Council considered those comments, and some of the thoughts and commentary of Council at that time included their recognition that this is a proposal for just one single dwelling on 1.7 hectares of land. And Council also acknowledged that there was an irony in this proposal, given that rezoning the property to R2 was requested in order to achieve a density that's lower than what is required within the R1 zone. Because of course the proposal is for just that one house, 1.7 hectares of land. Council also noted that a single dwelling on a large lot is a common development pattern within the area. And Council also determined that there would be a negligible cumulative impact with one dwelling in terms of traffic to the neighborhood. And Council also noted, as was noted in the previous slide, that the applicant has committed to the retention of as many trees as possible. And the proposed development in terms of the location of the dwelling, use of a private driveway, could very well isolate the backland from any further additional development. In February of this year, as is required by the Urban and Rural Planning Act, the file was referred to the Provincial Department of Municipal and Provincial Affairs, and they reviewed it and determined that this file did not generate any provincial interests, and that's the term that's used within the legislation. And they therefore released this particular rezoning proposal from any further provincial review. And then ultimately that was then further considered by Council's Planning and Development Committee, who referred it to the full body of Council, wherein at their March 1st meeting this year, Council adopted the amendments by unanimous vote. At that time, Council also appointed Commissioner Yefchek to hold this hearing and set this today as the date for a public hearing. On March 10th and 17th of this year, also as required by the Urban and Rural Planning Act, notice of adoption and public hearing was published in the Shoreline newspaper. Similar notices were mailed out to all known property owners within 100 meters of this property as well. And finally, we also posted similar notices to the town's website and advertised those through social media as well. Those notices called for any submissions for the consideration of Commissioner Yefchek. So throughout March and up to this week, comments were accepted for consideration by Commissioner Yefchek, and all the comments that we've received have been provided to the Commissioner. And there were 5 submissions made in writing in advance of the hearing. Of those submissions, one individual did not make a formal submission, but just indicated that they would attend this public hearing. And I believe Commissioner Yefchek is going to go through those submissions and address any concerns or expand on them as necessary. The town obviously is also aware of those submissions, and a number of them asked a few questions as well. So things like, would this development, if approved after the rezoning, if that's approved, would it prevent, for example, construction of a fence on an adjacent property? And there's nothing about this amendment that would change the town's fence regulations. So for example, a rear yard fence on any of the adjacent property is permitted, and side yard fences are permitted up to the front building line of the property that they're associated with. Front yard fences are a little bit less straightforward, but again, it's ultimately at the discretion of council if there's a established form of front yard fence within the neighborhood. There was also questions about whether or not this would be accessed by way of a private driveway or a public road. The proposal that we believe will come out of this rezoning, if the rezoning is approved and brought into legal effect, would be for a private driveway. And the water and sewer services would be by way of a normal residential service line that goes to the property. Just one other note with respect to requirement of the Urban and Rural Planning Act. It says that any amendments to official municipal plans must be certified by a member or a fellow of the Canadian Institute of Planners. I have managed this process from its initial stages through to today. And I do have the professional designation of NCIP, and I have certified the process up to current date. And if we get to a point where council makes a decision about the final version of the amendment, I will at that time review everything, ensure it's been done in accordance with the act, apply my certification if that's appropriate at that time. So just for some next steps, and I think Commissioner Yefchak is going to cover some of this as well. Commissioner Yefchak, after the conclusion of tonight's hearing, is required to submit a report to council. And but it should be noted that Commissioner Yefchak's report and any recommendations that he might make are not legally binding on council. Council's Planning and Development Committee will consider Commissioner's report and make a recommendation to the full body of council on a final decision. And that final decision can take a couple of different formats. Council can choose to approve the amendment as initially adopted. So what we currently have posted to our website, for example. They can modify the proposed rezoning by changing the zoning or modifying the lines or adding conditions, whatever they see fit. Or they can reject the amendment. And basically at that point, the process would stop. If council chooses to approve or modify the rezoning, the amendment must be submitted to the Department of Municipal and Provincial Affairs for registration. And that process includes a review by the provincial government to determine, to confirm whether or not the process and documents comply with law and provincial policy. And if it's registered, we would then be obligated by law to post a notice in the Newfoundland and Labrador Gazette, and the amendment would come into legal effect upon the date that notice is published. We believe that if the amendment comes into legal effect, the property owner or prospective property owner would then likely make a new application for the specific development of a single dwelling, as we've talked about earlier in this meeting. That concludes my presentation, Commissioner Yefchak.
Thank you, Mr. Davis. I do have a couple of questions, if you'd be so kind to answer them. I noticed in your slide deck that you had the concept plan for the I guess the location of the single dwelling. So is that something that's just a discussion point at this point, or has council made any kind of firm decision on the location of the dwelling?
No, that was tied to the initial application that was reviewed by council in June of last year. And that application was ultimately refused by council. But in speaking recently with the prospective owner of the property, if the rezoning is approved and comes into legal effect, the prospective owner, and certainly the prospective owner can speak to this of their own volition, intends to make that similar application at that time.
Apologize. I'm just taking some notes here. I apologize. Thank you. The next question I had in reviewing the submissions, and I've read them all, there seems to be a concern regarding the potential rezoning of the property. And looking at what's being proposed, Mr. Harris, and you can confirm this, the way I read the proposals that we actually have the initial request to for the property as a whole, but in fact, the area that's being rezoned is a smaller area of that property. Have I got that right?
Yes, that's correct. In reviewing the application, it was discussed with the committee and council, and a decision was made at that time that it's only the front portion of the property where the house is actually proposed to be located. it was only necessary to rezone that portion. There is also a wetland area towards the rear of the property as it goes, I guess, a little bit towards Windy Cove Lane. And it was felt as well that the zoning should not be changed in that general area.
Two more questions as you were answering. So that it's the front portion on Cherry Lane that's being rezoned, and I believe the zoning is, I think, R2, if I'm not mistaken, a residential medium density. But the rest of the property will remain as R1 or residential low density. So I know there's no additional access or not a wide enough access towards the rear of the property, but if the property could be obtained on the road at the rear for an access, then presumably some of that property could be developed under the R1 zoning. Is that correct?
Yes, but likely only if it were to be consolidated with other adjacent vacant lands. There's a large swath of undeveloped land to the rear of existing development that fronts onto Cherry Lane right now. And there's multiple property owners involved. So there would have to be a concerted effort by property owners to consolidate into a single ownership or to have a joint proposal for any further development.
And that leads to my last question. And that's the number of the submissions raise a concern about the, if this gets approved, what's to stop the property owner or the applicant to then move forward with, let's say, a road or additional lots from just that of the single dwelling. And if that was indeed a desire, what type of process, from what we're hearing right now, would that have to go through for council to give that consideration?
Sure, thank you. Any application of that sort would certainly be referred to council's Planning and Development Committee. It would have to be assessed in terms of compliance with the zoning, and if this rezoning proceeds, this particular property is going to be bisected by a zoning boundary between the R2 zone at the front and the R1 zone at the rear, which could make life difficult if someone were to propose a subdivision. Notwithstanding that, of course, council has the ability to require that any proposal go through a public consultation and or notification process. I certainly don't want to speak for council, but I think it is fair to say that council's attuned to some of the concerns and interest that development proposals on this property has generated over the last number of years. If you recall in my presentation, there was, I think, 4 separate development applications that had been proposed over the last number of years. At least one of them was subject to public consultation, which ultimately resulted in either the applicant withdrawing the application or council refusing it. And apologies that I don't know which scenario occurred, because that was prior to my time with the town.
Okay, well, thank you very much. I also imagine, is that, like, I think you said somewhere that it'd be a normal service line to the dwelling. I would assume if the desire was to go beyond that, then of course that service line would not be adequate to service a subdivision. Would that be correct?
Yeah, yes, correct. Any subdivision development would require an extension of municipal services. So obviously a 3/4 or 1 inch water line and a 3-inch sewer line would not suffice. The other challenges, just to sort of fill in the blanks here, that have been experienced with previous subdivision proposals is the grade of the property. It drops away from Cherry Lane, and any development, including this private development of a single dwelling, would likely require a sewage lift station. And obviously a sewage lift station designed to accommodate sanitary sewer from a subdivision is not a small undertaking from a cost and maintenance perspective. And that, along with the limited number of lots that was initially proposed in the subdivision proposal from several years ago, I think likely led to the project being economically unfeasible at the time. And I believe the property owner is on the hearing, and they may wish to speak to that if they would like to as well.
Well, thank you very much, Mr. Davis. I appreciate the presentation and your response to the questions. You certainly have enlightened me in a number of the matters I had some questions on. So again, thank you very much. The next part of the format is to now ask the applicant who has proposed a rezoning, LPM Consultants Limited, if they wish to make any comment or give any kind of submission or presentation. So is someone there on behalf of LPM Consultants that wishes to speak, could you let me know?
Yes, my name is Terry Party. I'm joining, I do have video, but no audio on computer, so I'm joining audio by phone. So it's a little bit broken, but I can certainly hear and I can see anything that's presented. I don't have a formal presentation at this time. I think Corey did quite a good job presenting the facts and the prospective homeowners' proposed development. There was never any intention to try to rezone this to further develop, but always and foremost just so the prospective purchaser could construct a single family dwelling on the house. So there is no further development. I have no intentions for any further development. And the homeowner's here as well, so she can certainly speak, or the prospective purchasers here as well. So just strictly to allow the development of just that one single home, and certainly my sale of the property to that prospective purchaser.
So, Mr. Party, I have really one question, and that has to, so in terms of the intention to sell a property, is it the full parcel of property that you'll be selling to the prospective the property owner, or will it be just the section that relates to the amendment?
The entire property. I have no more use for it, and the prospective purchaser wants to construct a dwelling, single family dwelling, and it's the entire piece of property.
Okay. Thank you very much. I have no further questions. So thank you. Moving forward, we do have the prospective applicant. I'm not sure that they wish to speak to their application, but if they so desire, please, you can advise me at this point, or if you're on the Zoom call and you don't want to say anything, then you don't need to say anything or make any kind of any reaction. So I'll just give a second.
Hello.
Oh, here we go. Yes.
Hi. Yeah, my name is Melanie. I also don't have any video right now, but I can see everybody clearly. So I can see you and I can hear you, just you can't see me right now. But no, I think that, like I said, Terry said it too. I'm been involved with this right from the get-go. I'm from CBS. So, I mean, the property is kind of like a really dream location for me. I'm from Manuals. And my intention right from the start was just to put in for a single family dwelling. This would be my first home of my own. And I'm just looking for I work at the fire department, so I'm just looking for a little bit of space and peace and quiet, and Cherry Lane is exactly what I was looking for. So I think Corey summed it up really well with his images and his slide deck. I'm open for questions if anyone has any questions for me, but in terms of comments, I think Corey, he summed it up perfectly with my intentions to leave as much of the natural landscape as possible, and basically maintain the integrity of the property and its natural topography and the wetlands and so forth. So, but I am here in case anyone does have any questions for me. So I'm open to that.
Well, thank you very much, Mrs. Barnes. I have no questions. I just want to give you the opportunity, if you so wish, to make some comments on, and you reiterated basically, as you said, what the current property owner and Mr. Davis has said. So like I say, I have no questions. Thank you very much.
Okay, thank you.
Excuse me. Now, I have received 5 written submissions. One, and first I should say, and I've said it earlier, I have read all the submissions. I've gone over them several times, so I'm very familiar with the submissions. One of the submissions, one respondent just wished to be invited to Zoom call, and I believe the person has been invited. Of the remaining 4, I will go through each one in the order in which I have received them. So there's no specific order to them, other than that's how I received them. I'm not going to read each one into the record, but I do have that. And as I said earlier, council will receive each one of these submissions as they review my report. And I know in terms of the typical legislation and so on, that the submissions will be part of the report, but the actual personal information will be redacted so that they're just dealing with the essence of the submission and not attribute to any individual person. What I will do is I'll go through each one of the representations that I have received. I will paraphrase what I believe is what I've read, and then I will ask the respondent by the property address to speak to their submission if they so wish. So I will start that, and the first submission that I have received is from 59 Cherry Lane. And again, I just received, this is the order in which I received it. This is all that I'm going by. The respondent has indicated at 59 Cherry Lane that they oppose redesignation and rezoning. They have expressed concern regarding rezoning to R2 will open the floodgates for future lots on 15-meter frontages along Cherry Lane and throughout the town. The respondent is concerned that there is no restriction which limits the development of the property to only a single dwelling, and has questioned what other types of homes can be constructed within the R2 zone. Respondent states that changing regulation hinders future prospective buyers who now cannot trust the regulations will be changed, thereby devaluing their investment. So that's how I paraphrased the submission. Is a respondent from 59 Cherry Lane wish to speak to, first of all, have I got your comments fully? Again, your letters here. And secondly, do you wish to speak further to your representation? So 59 Cherry Lane. I don't see anything from anyone.
The individual would need to unmute themselves.
Okay, I still don't see anyone. So I assume that I have captured the essence of what they are, their opposition and the issues that they brought forward. Okay, I will move forward, and if the individual still wants to speak, because they have not had an opportunity to speak, there is the oral submission. You can speak at that point since you have not spoken. The next representation I have received is from 77 Cherry Lane. And the respondent questions whether the access into the subject property will be a public road or private driveway with water and sewer services. And further, will this amendment and these services lead to further development of this property? The respondent believes that the development of property will have a negative effect on the value of properties, both directly to adjacent properties and indirectly to nearby properties. The respondent hopes that factors such as the effect on already heavy traffic, preservation of natural environments, and community ambience are all part of the consideration of the development proposal. Now, according to the respondent's letter from 77 Cherry Lane, they have advised that they are not able to attend the public hearing I will ask, is there someone responding from 77 Cherry Lane on the call, and do they wish to speak to their representation? Okay, I see no indication. So I move forward to the next representation I have received, and that is from 71 Cherry Lane. And the respondent has indicated that despite receiving earlier information from the town during the public consultation stage of this amendment process, a number of questions remain, and initial concerns regarding the amendment have not been alleviated. The questions and concerns relate to: number one, why is a rezoning required for a single dwelling? Secondly, is the access to be a road or laneway? Thirdly, how will the road affect the respondent's property? Fourthly, can the respondent construct a fence along the access boundary? And then lastly, concerns about no alternate route into the area. If the respondent is on the line and they wish to make further commentary or speak to their representation, please advise, and we will take your allow you to speak to your presentation.
Yes, I'm
Yeah, we're getting feedback right now from you.
yes. I think that's being taken care of. Yes, there were a number of concerns, but I think I think some of them are being clarified. But I do have a concern. My deep concern was the possibility of what might go in down later in that property and on a street that's already congested. Cherry Lane is narrow, and I'm a walker, and I know what it's like to feel walking on that street, how sometimes I have to move into other people's property in order for two larger vehicles to pass, one going up and one going down. I did have a concern of how it might affect my own property in terms of taxes if I now became a corner property. Those were two of my concerns, and I think that they still are, and I would hope that sometime there may be some further study as to what can be done to alleviate the problem of traffic on Cherry Lane. And I want to say that I have in no way what do I want to inhibit an individual from building a house on a property that they own. I was not clear that that the present owner and the applicant for the rezoning were not the one and the same person. So I'm glad to be clear that that is clarified, that the owner is not the applicant and the owner are not the one and same person. But I felt that I had asked that question previously in talking with somebody, and I was led to believe that the owner, the present owner, had made the application, but that was probably my misunderstanding. There needed to be some clarity there as well.
Thank you very much. I'm going to ask, if that's okay with you, Mr. Davis, I'm going to ask him another question if he can make himself available again.
Sure.
Yeah, Mr. Davis, I noticed in a couple of these representations, the issue of traffic along Cherry Lane and alternate route have come up. I know this application is for a single, the intention is to build a single dwelling, which is not going to be, in my view, significant additional traffic on that lane. But has there been any kind of consideration by council about that issue, about that concern?
I don't have any information right now that there's been any in-depth study or assessment on potential future traffic access points to the Cherry Lane area. Mr. Yevchik, I believe you're muted.
Actually, that's the way my wife likes to have me all the time. Muted.
Same.
Yeah, from the respondent from 71 Cherry Lane, yeah, I do have a commentary, and I think Mr. Davis has also explained the issue about the fencing. I think you can see that that should not affect your side or your rear boundary fence in accordance with the current fence regulations of the town. In terms of the access to be a road or a laneway, from what I've heard and what I've seen and what we've seen tonight, the intention is to put in a driveway to a single dwelling. So I trust those are a few more of the answers to your questions. I trust that's fine. Okay, thank you. No further questions. I will go on to the next representation which we received, and it's from 75 Cherry Lane. And I'll just read my synopsis, and then I'll ask the respondents to make a commentary if they so wish. Respondents from 75 Cherry Lane oppose rezoning of the property. The respondents have expressed concern that the rezoning will lead to further medium density development on this property. And this will be a precedent for the immediate area and the town, and will result in the devaluation of property in the immediate area. Concern is also expressed that Cherry Lane has no alternate access, and there's already a high volume of traffic on the street, which we've already heard a concern about that. Respondents note that the access to the property needs to be resolved prior to any development proceeding at 73 Cherry Lane, as early documents identify the property that fronts on the 70 Cherry Lane as a proposed road. And if this is no longer a proposed road, then access to the rear of the respondent's property will be prescribed by the owner, by the new owner of the subject property. This arrangement is not acceptable to the respondents, and the respondents indicate that they require ownership of a 6 meter wide strip of land which forms part of the subject property for purposes of snow clearing and maintenance, and access to the rear yard, which they presently enjoy. From their perspective, this issue needs to be resolved prior to the amendment proceeding. And lastly, they conclude by asking if there's only one residence on the property, why can't there be 2 driveways along this front section of the property at 73 Cherry Lane to provide driveway access to both 73 and 75 Cherry Lane. So that's my synopsis of your submission. Does anyone from any response from 75 Cherry Lane wish to make comments or further presentation?
Yeah, this is Velma Boudreau. I'm still not convinced that we are being dealt a fair deal here. As I mentioned, we bought our house, our land as a corner lot, and the town approved our driveway orientation, which is at the back of our property. And because until the proposed road went down, and then of course we would access our driveway from the proposed road. That was right from get-go. This was what we the town was aware of and what we did. I feel now that to have to access our driveway through, well, I was thinking it was going to be a right-of-way, but I hear tonight that it's going to be a private driveway. To access our driveway from somebody else's driveway, it just doesn't cut it for me, or for us actually. And so this will have to be addressed before any zoning change is made, as far as we're concerned. When I was speaking with somebody at council, I think it might have been Corey last week. He mentioned that he felt that the issues we had with the driveway would be between the owner and us, the new owner and us. And that being said, I still think that the town does have some responsibility in regard to us. I'll read what I wrote here today. In speaking with a person at the planning department last week, it was his stance that the driveway issues are between us and the owner. I contest that the town is directly involved and have been since 1989, when we were given permission to place our driveway to be accessed off the proposed road. We contend that our situation should be foremost in the town's decision regarding any rezoning and development of 73 Cherry Lane. The 6 meters that we use to access the back of our property has been maintained and snow cleared by us for over 30 years. In fact, we built the access off Cherry Lane that is now being used. And well, how does this involve the town? Well, like I said, to be fair to us, who have been long-time civic-minded citizens, we should not be thrown to the wind, having to access our driveway via a right-of-way, or now a private driveway, the terms of which are yet to be determined. We feel that since no town road will be built, we need clear title to the part which we have been using for, like I said, for over 30 years, which would limit the owner's frontage on Cherry Lane so that a medium density designation probably would not be possible. I think until this is settled with some kind of a legal agreement, we feel the town should not go through with the rezoning process.
Is it possible that you can email the commentary you just made to the town so I can have a copy of it?
Yes, I can.
And I'm probably going to ask Mr. Davis again as we're having this discussion. If indeed there was a selling of a portion of that frontage as being requested by the responsible selling from Cherry Lane, would this property at that point still meet the frontage requirements as being proposed by the current property owner?
Thank you for the question, Commissioner Yevchek. Right now, the property, as I understand it, has exactly 15 meters of frontage where it's legally required to be measured. If a portion of this particular property is sold outright to an adjacent property owner, it may very well prevent the development of this property because it may not very well meet the frontage requirement established in the R2 zone in the same way that it currently does not meet the frontage requirement established in the R1 zone.
Would there be any zone that it would be able to meet with 6 meters less as being proposed by the respondent?
I don't think any of the residential zones within the town have a frontage provision for single dwelling less than 15 meters.
If I could interject?
Sorry.
Yes. Sorry. I'm
Okay,
here.
go ahead.
I'm the Mr.
I see it.
Okay. If there's going to be a driveway, why can't there be 2 driveways?
You just explained that.
Well, yeah, I think that there's, as I see it, there's 2 issues that are being raised here. One is the issue of a driveway I guess, off a driveway, which is a concern from you as a property owners. And then the second issue is a matter of having acquiring land to make sure that you continue to have a driveway into the backland, as you've been enjoying for the past number of years. I would, I guess, and it's only a guess because I'm not a lawyer, but if you're looking for anything more than that, you have to kind of go to the point where Mr. Davis has kind of suggested that really probably this is something to do between the two property owners. I mean, there are things like easements, there's things like right-of-ways on existing properties, but that's usually a private property matter between the property owners. If there's looking to putting in acquiring land from this for your access, then that creates a situation where this would not meet any of the zoning requirements for the town. So that's, I guess, a consideration, which I will give in my report, but it certainly is a consideration that is kind of, I guess, for the town council at the end of the day to consider in terms of making a decision on this aspect of this amendment. I know that doesn't answer your question fully, but that's the situation as I see it. I do have another question of Mr. Davis for a second again. So the respondents have said that they were of the understanding some time ago that there was going to be a road going through this property, and that their house was situated basically as a corner lot with this road. I don't know if you've looked at the files or not, Mr. Davis, but is that certainly are you aware of that in terms of the town's files in terms of citing the dwelling in that regard?
So the property at 73 Cherry Lane, which we're dealing with tonight, certainly it's the remnant parcel of a much larger parcel that most of the properties on this portion of Cherry Lane and Windy Cove Lane were subdivided from. And although I could find no records to verify that assertion, it certainly makes sense given that it was a 15-meter width of land that was reserved out and not subdivided. Because of course 15 meters is a typical road right-of-way requirement. But having said that, I could find no actual approved subdivision development plans. We had the one subdivision proposal a number of years ago, but that was never approved by the town. And certainly in order to become a public road, the land would have to be conveyed to the town, and the town would typically only accept conveyance of land for that purpose after a road is constructed to town standards.
Well, we can certainly provide you with the legal documentation concerning the acquirement of the property in 1989. We have that.
With the lots drawn out.
Yes, we submitted that actually. You should have that there at the office. And that was our agreement with the previous owner of the property, which was Calvert Squires, was that we would use this proposed road as access to the rear of our property until such time as the town of CBS developed the road, and it was under their supervision. So in other words, unless the town developed this road and took snow clearing and maintenance of the road under their supervision, we were to use that access as we have been since 1989.
And you say that there's that information is with the town?
It is, we submitted it all.
Okay. Do you recall, and I know there was a plan, do you recall if that was a plan that was approved by the town council at that time?
Well, we bought the lot as an approved lot, and the town came in and okayed us to put water and sewer eventually on the lot. And that was the same as 71 Cherry Lane. It was the adjacent lot across the roadway. So in between 71 and 75 Cherry Lane, there was supposed to be the proposed road with a cul-de-sac at the bottom. We have no issues with the development of another house down there. That is not our problem. Our problem is, how do we access the back of our property in view of, let's say, when we go to resell the place? We can't just say, well, you know, it's all pending. We have to come to an agreement now as to how this is going to pan out. Our problem is accessing the back of our property and the snow clearing and the maintenance. On our property, we have constructed a retaining wall with a 6-foot fence, so it's impossible to be throwing the snow over our fence onto our lawn. So we have to be able to throw enough snow out of the way of the driveway so we can access the back of the house for numerous reasons.
Okay, I hear what the situation is, and I'll have to give it obviously a lot of thought. And I appreciate the situation that you're in. I really have nothing. Again, this is not decision-making meeting, and I've got to give that some thought as to how to proceed with your representation, which I will do. But I think I've heard what you had to say, and I've seen your kind of documentation as well. And I know, I believe council is aware of the situation. And when they see whatever my report is, I'm sure they will decide to give your concerns due consideration, as best I can say at this point. Do you have anything else to add right now?
I think that's it. Thank you.
Other than we can supply the legal documents if they don't have them, but they should have them, as we gave them to the town only a couple of weeks ago.
Mr. Davidson, do you recall seeing those documents?
Yes, we have a number of documents. There's currently an agreement between the owners of 73 and the owners of 75 Cherry Lane with respect to that access as they've discussed. However, it's an agreement between the two parties that the town's not party to. It is registered against the title of the property right now. We actually searched it. It is publicly available through the provincial government's registry of deeds. And at the end of the day, I think to an earlier question, there was, as Mr. Boudreau rightly pointed out, a subdivision plan that was illustrated probably at the time they bought their property, but I could find no records that the subdivision and approval of a road to the backlands through 73 had ever been approved by the town. And that remains in private ownership is testament to that fact.
Okay, so how was it we were sold the property and all those sites were submitted to the town, and the town okayed us to buy this corner lot, if you were unaware that there wasn't one even submitted? How did we come across all this is what I'm saying, and how did the town agree to us buying this lot, not having that information?
I don't know if Mr. Davis wants to respond to that, but certainly, Mr. Davis?
As I've stated earlier, the fact that there was a plan illustrating a proposed subdivision does not indicate that it was approved at some point by the town. And obviously, it certainly wasn't ever constructed. All of the lots that currently front onto Cherry Lane and Windy Cove Road that were subdivided out from the original parcel, which I believe originated from a Crown grant in either the late 1800s or the early 1900s, they would have been approved on an individual basis. And I'm not sure, the town has no role in approving someone's purchase of a property. We approve development. And at the time, I certainly can't speak to what considerations were made at the time that your proposed development, your house was approved, because it was long before I came to work for the town. And I have looked through the records, and unfortunately I could find no record of any implication that the town had agreed to a driveway access crossing a separate piece of private property.
Thank you. Yeah, I've got the essence of what, not more, I got more than the essence, but I understand what the situation is. I understand also your position and your opposition to the proposal as it now stands because of the issue of the driveway. So I will certainly keep that in mind in my report. I really don't have any more questions to ask. I think I've heard what I need to hear at this point. So, well, thank you. Unless you want to add anything else that you haven't already added.
No, I think we're good.
Okay, thank you very much. I appreciate that. And I appreciate you really elaborating on your situation and what you wish to kind of have as an outcome. So thank you very much.
Thank you.
So those are the written representations that I have received. If there, I'll go to the oral representations on the as part of the agenda. Is there anyone that has not made any presentation, written presentation or commentary at this point that may wish to make a presentation or commentary? Could you please advise me now? I know Mr. Davis is, and the staff are looking to see who they may be, if anyone. So, Mr. Davis, I don't see anyone. Is there anyone that come across your view?
I'm watching the background and I'm not seeing anyone use the raise hand feature or visually giving me a cue that they'd like to speak, nor has anyone unmuted themselves.
Okay, thank you, Mr. Davis. I think I got a good perspective on all the representations, plus what I've heard from the initial developer. I will give the applicant who has made the rezoning a kind of a last moment opportunity to make any further comments, since this is the one who is proposing the rezoning. So the applicant of the rezoning, LPM Consultants, do you have anything more you wish to add at this point? I do not see any response. Okay, so
Hello, hello, can you hear me?
Yeah, I can. Yes, sir. Yeah.
Sorry, technical difficulties. I'm speaking over a phone. The only comment I wanted to make is that some of the comments that have come from the neighborhood or communities, such as decrease in property value due to construction of a single-family dwelling. I don't think there's any merit to that. Increased traffic in the area due to a single-family dwelling. I don't think there's any merit to that as well. There's certainly not going to be no clear cutting on the property, which will, take away from the aesthetics of the community or the area. So I don't see any negative effect from the construction of a single-family dwelling. With respect to the 75 Cherry Lane, that's an issue between my property owner. It should be considered here and should not even be given the airtime to discuss it. It's going to be a legal matter between myself and the 75 Cherry Lane, and should not even be considered when the rezoning is considered. Other than that, I have nothing else to say.
Thank you, Mr. Purdy. In terms of kind of the raising the issue, and this is a public hearing, so the people who do respond do have a right to make the kind of commentary that they wish to make in terms of either opposing or supporting the rezoning. So, it was all done in accordance with the kind of prescribed procedures of a public hearing. So thank you very much for that.
I'm not saying they don't have the right to voice their opinion. I'm just saying that it shouldn't be a consideration in a rezoning application. It has nothing to do with rezoning of the property.
Okay, thank you. So having said that, and having heard all the representations, I'm going to kind of give concluding remarks in terms of this public hearing. First of all, for me, I've done a whole series of public hearings, and I always find going through the public hearing process is always an eye opener in terms of new information and new information. I've gotten, I think, good perspective of the situation and positions that everyone has regarding this proposed rezoning. So I just want to say thank you very much for your participation in the public hearing. I am required by the town to have a written report submitted to them within 30 days of the hearing, which I will do. This report will then be considered by the Planning and Development Committee and then by council. And then at that point, the council will make the decision. They will decide on this amendment, on whether to approve it, to modify it, or to review the amendment application. As was already mentioned by Mr. Davis, if it's approved or modified, the amendment will then go forward to the Department of Municipal and Provincial Affairs for review and registration. So that is a process. I will make my report and my recommendations to council as they have requested. Again, I just want to thank you all for participating and being frank and open with your commentary and your presentations. I also want to, I do want to, in closing, I do want to thank the town council for giving the opportunity for the residents of the town to make their comments known. I want to thank the staff for setting up this public hearing virtually during the ongoing COVID times that we're in, and by doing so, giving a voice to all who wish to participate in this process. Having said all that, I want to thank you for being appointed as commissioner, and I will now adjourn this public hearing, and I will say good night to you all, and have a good evening.